Hi, and welcome to the 11th episode of my vlog, Personal Injury Lawyer Tips. My name is Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing the laws that relates to the standard of care required by a lawyer. I've previously discussed the 6 elements that are present while establishing a cause of action for negligence against the defendant, which will entitle you to commence a tort action in the Superior Court of Justice in Ontario. And they are as follows. 1. Breach of the standard of care. 2. Sustaining actual damage. 3. Causation. 4. The existence of a duty of care. 5. Proximate cause and remoteness. And 6. Contributory negligence. If you want to learn more about the 6 elements of a cause of action for negligence, then please watch episode number 4 of my vlog entitled, What is the Cause of Action for a Negligence Action in Tort? All of these aforementioned 6 elements would still be present while determining whether or not you have a cause of action against the lawyer. However, the key element that's focused on in the legal analysis, which easily takes up the most time and is the most contentious in a negligence action against the lawyer, is ascertaining the appropriate standard of care required of the lawyer you're claiming negligence against. The issue essentially asks the question of whether the conduct or behavior of the defendant lawyer departed from the standard of care, an objective standard that an ordinarily and reasonably competent, prudent, and diligent lawyer or solicitor would have exercised in the same circumstances. The application of this objective standard of the reasonable person would constitute a higher expectation of compliance to the standard as it relates to professional persons acting within the course of their specialty, such as lawyers. So, what is the law as it relates to the standard of care required of a lawyer? The starting point is the 1986 Supreme Court of Canada case entitled Central Trust Company and Refuse, where Justice Ledane articulated the standard of care required of a lawyer as follows, quote, a solicitor is required to bring reasonable care, skill, and knowledge to the performance of the professional service within which he has undertaken. The requisite standard of care has been variously referred to as that of the reasonably competent solicitor, the ordinary competent solicitor, and the ordinary prudent solicitor. A solicitor is not required to know all the law applicable to the performance of a particular legal service in the sense that he must carry it around with him as part of his working knowledge without the need of further research. But he must have sufficient knowledge of the fundamental rules or principles of law applicable to the particular work he has undertaken to enable him to perceive the need to ascertain the law on relevant points, end quote. Therefore, the test relating to determining the requisite standard of care and skill required by a lawyer that you're claiming negligence against, further to the Supreme Court of Canada, is that of an ordinarily and reasonably competent, prudent, and diligent lawyer. Furthermore, if you're claiming negligence against a lawyer in a tort action, then it won't be enough to merely prove that the lawyer made an error in judgment or was ignorant of some particular part of the law. In order to be successful in your tort action so that the lawyer is liable for your compensatory damages, you have to prove that the lawyer's error in judgment or ignorance of some particular part of the law was such that an ordinarily and reasonably competent, prudent, and diligent lawyer who brings reasonable care, skill, and knowledge to the performance of his or her professional legal services and duties would not have made or shown it. So finding that your lawyer committed an error of judgment or is ignorant while executing a widely recognized, respectable, and adopted legal approach in your best interest, the retained client, doesn't prima facie mean that the lawyer was negligent. If it is established that your lawyer committed an error of judgment or was ignorant of some particular part of the law, then it only follows that your lawyer may or may not be negligent. because it ultimately depends on the nature of your lawyer's error or ignorance. Again, if the evidence established that your lawyer's error or judgment or ignorance was one that wouldn't have been made by the average or ordinarily and reasonably competent, prudent, and diligent lawyer within the same scope of legal practice, while bringing reasonable care, skill, and knowledge to the performance of that professional legal service undertaken on your behalf, which constitutes the special group that your lawyer belongs, then there is a high degree of probability that your lawyer will be deemed to be negligent. Lastly, even if your lawyer is a specialist in a particular area of law, who, like a lawyer in general practice, owes you, a retained client, a recognized duty of care in tort and in contract, your specialist lawyer, again, is only expected to demonstrate a fair, reasonable, and competent degree of skill within the specific scope of his or her legal practice, or the average group of specialist lawyers that he or she belongs. But your lawyer is not required to use the highest degree of skill, because there may be lawyers who have higher education and greater advantages. I hope you found this information valuable. If you want more information, then please read my blog of the same name called "What's the Standard of Care Required of a Lawyer?" In my blog, I take a deep dive into the standard of care required by a lawyer. I also provide links to other blogs such as "What is the Cause of Action for a Negligence Action in Tort?", which provide additional information that you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you. And I'll see you soon in episode 12, the final episode of season 1 of Personal Injury Lawyer Tips, where I'll discuss what's the standard of care required of a doctor and bring you more useful legal information. Thank you.